Hello, Nick. How are
Hi
you
there,
doing?
Bruno. How's it going?
I'm good. How are you doing?
I'm good, and you?
So sorry to our viewers. So Solna got caught up in a bit of technical difficulties in a previous webinar she's doing, but we're always happy to obviously have you here. So
Yeah, it's
yeah,
becoming a regular thing at this point. I might have to
it
take
is. It is. It is. It is. So yeah, and as I said before, when Solna comes back on, she's going to be the guest.
There we go.
Cool. So getting straight into it, we have two questions. They are they related to each other. But yeah, we're going to answer them very specifically so that people get the value out of both styles of questions. So, Nick, do you want to hit me with the first one?
Perfect. So the what this relates to specifically, the question is actually an article that was published on Cliff Decker Hofmeer's website, but specifically it relates to the application of Voetstoots, as well as the Consumer Protection Act in the circumstances, and how those two different ideas sort of interplay. So look, the article does an explanation, but obviously we'd like your explanation in the circumstances of those two, ideas and how they interact with one another.
Sure. And I see that the article is also a 2015 article. So since then, there's been quite substantial case law on the interpretation. And so obviously what the viewers need to understand is the way our law typically works is the legislator will come out with specific provisions, but the courts have to interpret these. And as the courts interpret this in practice, as practitioners or consumers or whatever the case is, we have a better understanding on what the intention is on how to actually apply these clauses. And you'd be surprised that the interpretation is crucial, because sometimes just the stating of a certain right in a piece of legislation doesn't really give a lot of depth or meaning as to how that right's supposed to be enforced. And the reason I'm mentioning this specifically is obviously the Consumer Protection Act is something that is litigated on quite a lot. So there's a lot of case law that deals with how these protections, how it's going to be approached, that sort of thing. And the Voetstoots clause was actually one of the first things that came under the spotlight when the Consumer Protection Act came out, because in terms of the CPA, the general perception is that Voetstoots is done away with. We don't, there is no such thing. So maybe just for the sake of context, just in case. So all Voetstoots basically means is as is. So when a person buys a property or does anything, any sort of transaction, if you use the terminology Voetstoots, you're typically trying to say that I'm selling this product, I'm selling this land, I'm selling whatever, but you're buying it exactly as it stands. So if there's issues with it, sorry, you know what, it's your problem. We're not taking any responsibility for those issues, right? So that's the typical understanding of Voetstoots. CPA comes out and says, but tries to protect the consumer against such a thing. So people's natural assumption is to say, great, Voetstoots no longer applies. We've all got all this protection in the world. So that's the first kind of myth that we need to bust, is Consumer Protection Act applies between a supplier and a consumer, right? It tends to be a business relationship. So a supplier is someone that's providing products or services in the course of their business, and the consumer consumes these goods or services. Now, if that relationship is not a supplier-consumer relationship, the CPA won't apply. So that kind of busts the first myth already. If it's a private sale where I'm selling my house, not necessarily for profits in the course of my business, I'm selling my house and I'm selling it to somebody else privately, Voetstoots can actually still apply. The Consumer Protection Act will not protect you. So you need to make doubly sure who you're buying the property from and whether they're in the business of selling properties or not, because if they aren't, be careful, Voetstoots could very well apply. And that leads to a conversation, because the next question is like, oh, but that's terrible. So Voetstoots applies. What if this guy hides things? Fortunately, that's the one situation Voetstoots would not apply in a private sale, is when it's intentional. So if somebody actually hides a defect because it's latent, so you can't see it anyway, and they hide it, you're good. The only problem. So it's nice in law to say, no, you're good, you're protected. But in practice, the reality is you need to know that he tried to hide it. And how do you prove a person hide a defect that isn't as apparent. And I usually use the story where one of my clients bought a property in a sale and execution. He bought it during winter. The idea with these clients is they used to flip the properties quite quickly. So he took on the property, found a purchaser also during winter, and sold on the property to this purchaser. What they didn't realize is it was during summer, because it was at the end of the panhandle, it wasn't constructed very well. So it used to flood, and it used to flood consistently during summer to the point where there was erosion, degradation of the foundations, etc., etc. And my client was my client at that stage. The conversation came up, and was this his business? Wasn't it his business? But the reality is, when we actually looked at the outlook and whether he knew about it or not, and whether a clause, Voetstoots clause would apply if it was to be considered a private sale, became so difficult because he did not intentionally hide it. He did not know, because in winter it doesn't rain. So it's just an example on where the CPA offers protection versus a private deal, and where Voetstoots could apply. In terms of the CPA, Voetstoots won't typically apply, because if there's a defect, you're allowed to send it back to the supplier, and you can cancel the contract, claim some sort of compensation or reduction of the purchase price. If CPA doesn't apply, be very careful, because then Voetstoots could very well come around to bite you, unless you can prove that the guy actually knew about the defect, which is very difficult to prove.
Absolutely. Couldn't have said it better.
Nice. Thank you.